Hello guys, I'm back to do a video on real property landlord tenant law, and this is good for writing up an essay and also for your MBEs. This comes up a lot on MBEs too, the different portions. Okay, so landlord tenant. A tenancy is created when an owner of land conveys to another a lesser interest in the property. In addition to the life estate, there are several types of tenancies, and we'll go over those, several types of them. Several types of tenancies are tenancy for years, periodic tenancy, tenancy at will, and tenancy at sufferance. Talk about all of those. Tenancy for years has a fixed period, so you're going to see dates on there, a beginning date and an ending date, and if it has both the dates, and you automatically think of a tenancy for years. It can be 1 day, 2 months, or 1 year. Statute of frauds is required for more than a 1-year lease. We all know that. Automatic termination is the end date. So it's an automatic termination at the end date because it gives you an end date. It's automatic, okay, for the termination on this one. Periodic tenancy automatically continues from one period to the next unless one party terminates the lease by giving the notice of termination. It's a month-to-month or a year-to-year. It's sometimes created by implication. So if the lease includes a start date but has no end date, it's an implication, okay? Periodic tenancy is created by implication. Written notice required for termination. So this one you need a written notice. And usually for common law, the notice length of time period, for example, if it's 2 years, they're going to say that if it's, let's just say 6 months, because there's an exception here. If it's 6 months long, then they're going to require a 6-month notice to the tenant or a 6-month notice to the landlord if you're trying to terminate a periodic tenancy. So the termination is as long as the length of time of the period, okay? Except if the lease is 1 year or longer, all you need is a 6 months notice. So you got to keep those dates in mind because a lot of MBs are on those. Holdover tenant is when the tenant decides not to leave. The lease is terminated and T does not leave and tenders rent, which the landlord keeps accepting. So now this turns into a periodic tenancy, being the time period of the previously expired lease. So they're going to use the previously expired lease. That's the time period, and the holdover tenant is going to be required to adapt or follow all the elements of the periodic tenancy. You do see MBs on this where the owner continues to take their rent. Tenancy at will, a tenancy for no fixed period of time. There's no dates, which can be terminated at any time. Can be created by implication and terminated at any time by either party. Tenancy at sufferance. This is when the tenant wrongfully holds over past the expiration of a valid lease. It expired, it's over, and the tenant wrongfully holds over, holdover tenant. The landlord election, what can the landlord do? So if the tenant holds over, the landlord has the option to evict tenant or hold over tenant to another term as a tenant using the periodic tenancy. Okay, so if they decide not to leave and you continue taking their rent, you can hold over the tenant, but the tenant now has to follow the periodic tenancy rules and regulations, okay, which we just went over. You see those on MBEs also. Common areas of dispute. This is where commonly there's a dispute in the essay or a dispute in the MBE. And duty to pay rent. The tenant has a duty to pay rent. He may have the following defenses for not paying his rent. Usually these come out in essays. Failure to deliver possession of premises. So the landlord did not deliver the premises. So D can withhold the rent, and that would be a defense for him. Breach of the quiet covenant, implied quiet covenant, and enjoyment covenant, which I'll go over later. Constructive eviction, destruction of the premises, no fault of the tenant or the landlord. So in common law, the tenant must continue paying rent. Modernly, tenant can terminate the lease. Okay, so you need to write on both. That's what real property has for landlord tenant is writing on both the common law and modern law. Potential contract defenses such as frustration of purpose is also a reason for the tenant defending that they're not paying their rent. Surrender of premises by tenant and landlord accepts the surrender, so they can stop paying rent for that. Reletting of the property after an abandonment, new tenant rent is less. Let's just say the new tenant rent is less than the old tenant. The old tenant will need to pay the rest as long as he is notified. So the landlord needs to notify that tenant. Possession of the premises. A holdover tenant, common law, you can use self-help, go in there, take them out. Modernly, there's no self-help. Eviction through the courts and you sue for damages. Abandonment, T leaves. If T leaves, the landlord can accept the surrender and terminate the lease. Relet on behalf of the tenant. Remember, that's up here. If he relets it and the new tenant is paying only less, then he can go after the original tenant to pay the rest, if he notifies him. So he must notify the tenant of him reletting to the new tenant. Or you can leave the premises vacant. He can leave the premises vacant and sue for rent. Traditionally, there's no duty to mitigate, but modernly, they do want them to mitigate their damages. Look for a new tenant, okay? Rental premises. Ooh, this one looks messy. What happened here? Let me take care of this real quick. Hurry, I gotta get this done. That's good for now. I'll fix it later. Okay, so rental premises, common law, tenant takes as is, and the landlord has no duty to repair. That's common law. Common law is usually not as strict as modern law. So the tenant takes as is, and the landlord has no duty to repair. Modernly, the landlord must maintain all common areas, fix latent defects. If the landlord has knowledge of the latent defects, he must have knowledge of them. If he makes repairs, he cannot make them negligently. Okay, no negligent repairs. The implied covenant of quiet use and enjoyment is implied in every single lease. So landlord or anyone acting for him, like his agent, cannot interfere with the quiet use and enjoyment. But this does not include acts of strangers. So if landlord doesn't know of them or doesn't have them go look at the premises, then that's considered a stranger. Constructive eviction, residential, commercial, must be a substantial interference with the property. Notice must be given to the landlord. I see this a lot on essays. Substantial interference, the water's not coming out hot, or the shower's not working right, stuff like that. There has to be a substantial interference, okay? And the tenant has to give notice to the landlord. If the landlord does not respond and causes T to move out within a reasonable time, then construction eviction will be granted. This is residential or commercial property. Actual eviction, a tenant excluded from the entire premises due to a holdover tenant or paramount title holder. We talked about that. A partial actual eviction, landlord makes improvements for tenant to live on a partial. So landlord does not actually, landlord makes it physically impossible, for the tenant to occupy all or some portion of the premises. The tenant may withhold the entire rent and does not have to move out, okay? Implied warranty of habitability applies to residential leases only. Sometimes you'll see on MBEs or an essay, it's a commercial lease. This does not apply to them. Must be fit for human habitation. Where the premises are not habitable, the tenant has the option to, let's see here, terminate lease and move out, make repairs and deduct that from the rent, or pay reduced rent and remain on premises and sue for the damages. Okay, and retaliatory eviction is totally barred here. And I get that a lot of MBEs where the landlord does something to retaliate against this person because they've put in they said that their place is not fit for human habitation, and the landlord does something to retaliate against them. That is barred. That is not allowed. Let's move on to the next one. Tort liability of landlord and tenant. The landlord must maintain all common areas, fix any latent defects. We talked about that. We must have knowledge of them. Any repairs and not make them negligently. Duty to inspect for defects if the premises are held open to the public, okay? Tenant is treated like an owner for purposes of tenant liability to a third party. If they invite someone over, they're treated like the owner, and the third party comes on the property, okay? So that's gonna be basically what their liability is here also, if they have people visiting the property. Doctrine of waste, there's voluntary waste, permissive waste, and ameliorative waste. Voluntary waste occurs when a tenant engages in conduct intentionally or negligently that causes a decrease in the value. That's voluntary. Permissive waste occurs when the tenant neglects the property and it falls into disrepair or does not make ordinary repairs. He lets it fall apart. Ameliorative waste occurs when a tenant makes substantial alterations to the property. Even if it increases the value of the premises, the tenant must restore the premises to the original condition. So these are the doctrines of waste. Sometimes get these on MBEs, and sometimes I've seen them on essays where we have to write up all three. Fixtures. Fixtures are items that were once movable, chattel, but that have become so attached to the premises, they are deemed fixtures and considered to be part of the real estate. The courts consider the following. What's the method of attachment? How did they attach it? Adaptability, removal, can it be removed without damages, intention, And is there agreement? Sometimes in the MBs, there's an agreement between the landlord and tenant to go ahead and put in a new stove, a new carpet, new refrigerator, and those are considered fixtures. So if the tenant wants to take those at the end of the lease, he's allowed to. Okay, so if there's an agreement, you need to look for an agreement in there and write up the facts and analysis on the agreement. Now, assignments and subleases are everywhere. They're in essays, they are in MBEs, just basically has to be memorized. The general rule and interest in a lease is transferable unless the parties agree otherwise. Prohibitions against assignment and subleases are enforceable. And I have seen MBEs on this where they put in a sublease and then they have an assignment prohibition by the landlord and the tenant agrees, and then he decides to sublease it. They would consider that, because assignment and sublease are so close, that they would consider that enforceable still, the prohibition against both the assignment and the sublease. So those are kind of tricky sometimes. I'm trying to find my annotate here. Here it is. Spotlight. Okay. Assignment. This means that the person is transferring the entire interest. The new tenant is personally liable to the landlord for rent because of privity of estate. The old tenant is also liable to the landlord because of privity of contract unless there's a novation. If the landlord releases and gives a novation, old tenant is free to go and the new tenant will be liable. But if not, the old tenant and the new tenant continue to be liable to the landlord for rent. In a sublease, you're not transferring the entire interest, you're transferring some piece of the interest, okay? The new tenant is not personally liable in a sublease because there's no privity of estate, and the old tenant is liable for privity of contract. So new tenant's out, but old tenant remains liable. That's pretty much it. I'm going to go over the approach real quick here. So approach to landlord tenant. On an essay is to write your rule. What type of tenancy in it is it? I went over those: tenancy for years, periodic tenancy, tenancy at will, or tenancy at sufferance. Are there any disputes that you need to talk about, like duty to pay rent? Do they surrender the premises? All of that. Are there, is the doctrine of waste going to be in the facts? You need to write on all three usually. Are there any fixtures? A fixture dispute. Let me put my question marks here. So waste if needed. If you see anything like they're chopping down trees or not taking care of fixing the premises. Fixtures, are there any fixtures that need to be addressed? Fixtures, trade fixtures, and come on. Did I do the fixtures? I don't see the fixtures. Oh, we didn't go through those. I didn't do the, let's do those real quick. Trade fixtures are different. They're commercial fixtures. So basically it's for a business. It's a strong presumption they are removable, okay, because they go along with the business. But if they are removed and the tenant causes damages, they are responsible for fixing those damages. And those are for commercial trade fixtures, okay? And I went over regular fixtures here. Now let's go back to our approach. Assignment, sublease, these are big on MBEs. And then your conclusion. Okay, so rule, type of tenancy, is there any disputes? Is there waste involved? Is there any fixtures involved? Is there assignment or a sublease involved? And what are the conclusions of that? And that's the approach for writing up a landlord tenant essay or portion of the essay, and also helps you with your MBEs. And I'll see you guys on my next video.